Hey guys, so I decided to do the liability and the substitute teacher where Linda Collins was employed as a substitute teacher for Walnut Grove High School in a mid-sized industrial city. She generally substitutes 15 to 20 days per month at various schools in the district. On the day she substituted in a shop class, one student was sexually assaulted by another student behind a portable chalkboard. Parents of the assaulted child filed a suit against the school district. So the first question that I'm going to address is a substitute teacher held to the same standard as a regular teacher? And I think that yes, the substitute should be held to the same standard as a regular teacher, because when she decided to take that job as a substitute teacher for the day in that school, she became the educator that was needed to instruct, supervise, and provide safety for those students. So I also think it's important that administrators and board employees know who are entering their school and educating their students, because because of loco parentis, the teachers are then have that obligation to take necessary measures to ensure that the school environment is safe and conducive for students. Substitute teachers should know the rules, regulations, and expectations of the school that they substitute in, so incidents like this can be handled more effectively and efficiently. Does sexual assault of a student by another automatically result in liability? I said yes, and I felt that there were more than just one person that could be liable for this situation. One is definitely the substitute teacher. She failed to realize that the portable chalkboard could obstruct her view from properly supervising the entire classroom. I would consider this almost an act of negligence because it resulted in a lack of care. It resulted in a breach of duty because she's supposed to be supervising the children. And then finally, injury was a result based on her breach of duty, so that is the proximate cause. I also feel that administrators could be held liable for the sexual assault, and I read that because of the Doe versus Taylor case that involved sexual abuse of a female student. The principal should have known the girl's constitutional rights to be protected from sexual abuse, and then of course they have that duty to protect that student, which didn't happen. Also, if the principal was aware of any kind of situation going on between the two students beforehand and did nothing to protect that girl, then that principal is liable for what happened in the classroom as well. And then finally, the school district or the school board of education could be held liable. And this I kind of found more to be tied towards like a Title IX incident. So Title IX basically was passed in 1972, which states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Okay, and then thanks to the case of Alexander versus Yale University, the federal courts first recognized that sexual harassment in education violated Title IX. And numerous district courts have ruled that schools are liable under Title IX if they fail to prevent a sexual harassment by a student to another student. What factors would determine whether liability claims are valid? Well, there's two types of TORs that we learned about, intentional and unintentional, and I feel that this was considered unintentional because of negligence. So negligence is generally viewed as the failure to exercise the proper degree of care in doing what is otherwise permissible. So I feel like the substitute needed to have a respective standard of care where she's responsible to have that same degree of care that other professional educators would have in this certain situation, and she didn't. She lacked the ability to supervise the class effectively. And like I talked about earlier, I really feel that there was a breach of duty since the substitute teacher didn't supervise the class the way that she needed, and because of proximate cause, there was an injury that was sustained because of her breach of duty or lack of supervising the class. Unfortunately for this school, I feel that the court will side with the parents. There were a lot of different things that the school educators and administrators and the board could have done to prevent something like this. So thanks to, the girls' constitutional rights and previous cases, the parents have a lot of things that would help the court back their decision of filing, a suit against the school district. I feel that if the substitute in particular had been more aware of what was going on in the classroom, that this wouldn't have happened. Also, as a former substitute, I think it's important that substitutes take a class or have been in education classes before they are allowed into the classroom so that incidences like this won't happen again.